Hello and welcome to the ThinkSports podcast. Today we have with us Shatadru and Ainesh. Shatadru is an advocate at Legal Options, and Ainesh, who has a management background, is also exploring the domain of law, working with legal options. But at this point, he's like at a crossroads between the two domains, management and law. We are going to discuss law in general, but more particularly sports law. It's a domain that we haven't discussed on the podcast before. So it's going to be an interesting introduction to sports law for us. Shatadru, maybe I'll start off with you. Can you explain to us your experience working in sports related projects in the past and maybe in the present if you're working on something currently?
Yeah. Thank you, Ronojit. I would like to thank you for this opportunity to speak on the subject of sports law or the interplay between law and sports. And before I come to our specific experiences in the field, I would like to briefly discuss what sports law is all about. Because you see, law is nothing but a set of rules which govern relationships which are contractual or relationships which are even non-contractual but involve individuals and entities, which maybe individuals, maybe corporate entities, maybe associations of individuals, partnership concerns, etc. But what is fundamental to the applicability of law is that it requires more than one individual, and secondly it requires some kind of relation. So that relation could be a corporate relation, it could be a jural relation, it could be a contractual relation. Now the interplay between sports and law also arises because of the like any other field, as our society progresses and as there are greater complexities, as the scope of things expand, so to say, things get complicated. There is a greater interplay between individuals, and there is a need to bind individuals through this chain uh, of rules and obligations, which is what the law is all about. So therefore, sports law becomes relevant, or sports law becomes a field in itself, because of the fact that sports is probably ancient. I mean, we know of the Olympics in Rome. So, but because of the manner in which sports has progressed, has expanded its footprint all over the world, and it is not merely a group of people enjoying themselves or doing an athletic activity, but it is really a big business, and it has so many dimensions to it, be it broadcasting, be it players' rights, be it anti-doping, uh, be it associations, sports associations. So therefore, because of the interplay between all these different entities, and because of the complex and intricate nature of international sports today, that you have this whole burgeoning field of sports law. So that explains why at all you have something called sports law. Now, coming to my personal experiences, I would at a very general level, I've had the opportunity and the benefit of dabbling in this field of sports law in the last 10 years of my practice, and it has been in diverse contexts. It has been in the context of sports associations, where there are disputes inter se between the members of the association. Then there are disputes between different sports associations, between themselves at the state level, at the national level, even at the international level. And also in the realm of sports sponsorships of sports entities such as clubs and associations, which collaborate with various corporate sponsors or third parties, with a view to kind of meet the requirements of a very competitive and fast paced international and national sporting scenario, where uh, clubs and teams and associations need to be completely at pace, so far as corporate sponsorships are concerned, so far as employment of top-notch talent is concerned, so far as expanding the footprints of a sporting entity such as a club to allied fields such as merchandise, such as brand endorsement, where the sports club or the sports entity itself is a brand which is tapped into by various corporates and by the club itself, so as to commercially exploit its name or to commercially exploit its brand, with a view to self perpetuate itself and to make it a viable commercial venture for itself and also for its players and for the sporting fraternity as a whole.
I think it's clear for us to see that it's definitely a very vast topic. Like any other field in law, it has many aspects to it. One thing that you talked about that we'd like to highlight is the contractual obligations part. So, if you're a sporting entity, if you're, say, a football club, you have players contractually obligated to play for you. In light of the global pandemic, do you think like there are a lot of complications to player contracts? Does it change, the specificities in the contract itself? Is the pandemic one of the situations where a lot of things in the contract might not be applicable at this point? Can you highlight what challenges an organization would face when dealing with such contracts when certain emergencies like the pandemic may arise?
Yes, of course. So the pandemic is a situation which the whole world and the whole commercial world is grappling with at the moment. And as I mentioned, you see, be it sports, be it any other field, eventually it is bound by a chain of contractual relations. So be it between the player and the club, or say be it the between the club and say its sponsors, it be it their broadcasting sponsors, merchandise sponsors, or even say between maybe government entities and the club, between different sporting entities across nations, and between say organizers of say tournaments and these sporting entities. So all of these are a chain of contractual relations. So as with any other contractual relation, uh, events like the pandemic have a definite impact. So sports contracts are no exception to that, and therefore one has to look at the pandemic, at the novel coronavirus epidemic, as a force majeure situation. And a force majeure situation is a common law concept which acts as an exception to performance of contractual obligations, which kind of waives by operation of law the obligations of parties to perform under a contract. And it is a standard clause that you will find in almost every commercial contract, where parties are partly or wholly exempted from performing their obligations under contract in the upon the occurrence of one of the several force majeure events, which could include a plague such as the present pandemic, or it could also include things like floods, like uh, like uh, uh, earthquakes, like fires, or any other such situation which is beyond the control of the contracting parties. So there is a broader concept of vis major, or act of God in common law, which is basically which is basically another term, so to say, for a force majeure event, which is basically these are events which create a situation of supervening impossibility of performance. So therefore, if the performance of contractual obligations becomes impossible for no fault of the parties, then parties are entitled to take the refuge under this principle of force majeure, and their contractual obligations are either waived or they are suspended for a certain period of time, within which it is reasonably expected that the force majeure event will pass, or there will be greater movement towards normalcy. Or in the further alternative, after this, where it appears that there is no reasonable likelihood of of things normalizing, the contract may provide that the parties will be at liberty to terminate the agreement, and there will be no, whatever obligations have already been incurred before the force majeure event has occurred, or perhaps it will provide for that. Or there might even be a complete accord and satisfaction so far as the mutual rights and obligations under the contract are concerned. So definitely, just as in any other contractual sphere, force majeure events have their definite set of consequences even for sports contracts, which could include, as Ainesh will also give you will explain that in the context of some of the recent events in the world of sports, where individual sports persons have got into disputes with their parent bodies or their employers, and they have found a way of resolving the issue. And so therefore just to before I hand it over to Ainesh, a given force majeure event could mean that the club is not obligated to pay the players, or is not obligated to pay the players for a season where there is no sporting activity on account of an event such as the pandemic. But of course, there could be greater complications. For example, if at the end of the day, a player signs up for one club. So in effect, even if he is not an employee of the club, the relationship is somewhat akin to that of an employer-employee, because he doesn't have any other source of employment. So how that will, of course, work out, as will also appear from Messi's example, which I think Ainesh will elaborate further, that it also depends on the kind of player, what is his bargaining power, and how well he's placed so as to negotiate with the club. Ainesh, why don't you throw some light on the
Yeah, so
real life
basically,
example?
like I was, because of the pandemic, I was really interested to see in football how would transfers actually happen, right? So like how would the clubs get creative and stuff like that. But like two deals, like Messi's deal obviously was the news of the transfer window, but two deals that actually really stuck with me were made by Tottenham. So Gareth Bale's loan deal and Regulon's move to Tottenham. Both these deals had such complexities because Real Madrid said for the Regulon deal, they said that we want a buyback clause, which basically means that in the future they can buy him back from the club at a specified amount. So these small things which were added to the contracts to make it more creative, like just to favor them when the clubs were not willing to spend cash, was really interesting to me. And obviously Messi's deal was like the news of the summer, right? Like he wanted to leave and he was not allowed to leave because of a small thing where it said end of the season, and because of COVID the season was extended. So based on technicalities, he was not allowed to leave. If in a way, if you see.
So what's interesting about that is Shatadru spoke about bargaining power
Yeah,
in these situations when it comes down to where you are placed in terms of your relationship with the club and things like that. But the Messi situation was complicated in that he had a specific date before which he had to terminate his contract, which I think was the 10th of August, if I'm not wrong. And the season extended beyond that, and that was what Barcelona was kind of arguing, that because the date has passed, he cannot terminate his contract and leave on a
yeah.
free. And what I want to know from either you or Shatadru, maybe can weigh in on this as well, is if he kind of forced a move out and that actually went to court, where Barcelona kind of sued him, took him to court, where do you, in your like legal opinion, how do you think that hearing would go? Because it seems like both of them have fair arguments, but what is the legal kind of aspect of that?
So,
Um,
uh, um, so therefore, it will actually depend on what the exact language of the contract is. It will depend on um, what is the intention of the parties when the contract is executed. So, for example, if it is clear from the reading of the contract that the parties are bound to continue with this arrangement for a certain duration of time, and it was the intention of the parties that this contract will not be terminated before expiry of that period, then possibly the court will take a view which is favorable to the club, as opposed to a situation where the reading of the contractual terms indicate that although it was for a certain duration of time, the understanding between the parties was that it could be terminated at any time prior thereto. So of course, see, eventually this will result in larger questions as to whether you can have a contract which is not terminable at all. Like eventually it is, so the molding of reliefs will happen like this, that a party, say for example, if the club were to approach the court, they would seek a specific performance of the contract. They would seek a decree from the court that that the player be compelled to continue playing for the club. Now the court may or may not grant that relief. The court, if even if the court assuming that the court is convinced and is satisfied with the contention raised by the club, that there was a breach on the part of the player in not continuing with the contractual agreement, the court may still direct the player to compensate the club in damages, as opposed to compelling the player to continue playing with the club. Because eventually contracts of this nature, I mean, there's one school of thought which will which would suggest that contracts of this nature are by their very nature terminable. You cannot force a person to a party to an agreement to keep performing or to keep playing for a club. I mean, you can always, if you feel that there has been a breach, you can direct that party to compensate the party which is alleging the breach, but you cannot possibly compel a player to continue playing. I mean, it all depends on what the exact wordings of the contract are, how the court, whether the court feels that damages can be a compensation. For example, an argument against grant of alternative damages in courts is to say that the breach is such that it cannot be compensated in damages. So for example, if I was conducting the case for the club, I would try, my effort would be to demonstrate that the club put in so much of, changed its circumstance in such a way. It put in so much of money, so much of publicity, so much of the opportunity cost was such that to go for player X, it let go of player Y. And because of this, its chances in a particular season are affected by the absence of this player. Its chances in a particular season would be affected so irreparably that mere monetary compensation would not suffice. So in a situation like this, the court may be convinced to reach a conclusion that no, for this season he has to play. Because it is not, for example, if a player decides to walk out of a contract, say 2 weeks before the tournament. So in such a situation, obviously in 2 weeks time, it is not possible for the club to get another player or a player of the same standing. So in a situation like that, it might very well be for the arbitral tribunal or the court to say that no, it is not possible. No amount of money compensation can suffice, and you have to play this tournament. After that, if you have to part ways, you have to part ways. But as far as this tournament is concerned, you have to go ahead and play. But on the other hand, there could be a situation where the player indicates in the beginning of the season itself that he doesn't want to continue. So then there may be enough time for the club to find a replacement, or say if they can quantify the losses that they have suffered or that they will suffer as a result of this player backing out, and they can put a figure to that, and they can satisfy the court that this is the total loss that they are likely to suffer, then the court will probably compensate them in damages without forcing the player to keep playing for the club.
So that's actually very interesting about how you would approach arguing for the club. It's it's always been weird to me how they would kind of quantify these values, how they would quantify their losses in terms of losing a player and things like that. But what I've always been curious about is in terms of having to pay damages to the parent club. Let's say someone is leaving or is trying to leave club A to move to club B, and the courts say that club A has to be compensated in how you explained it. would club B bear compensation, or is that something that would just have to be borne by the player himself in order to
No,
force his move?
it all depends on the facts, no? Like for example, if the suit is, if for example they are able to establish that the second club has a role to play in this departure, maybe a suit can be framed in a manner as to make the other club also a party because the other club is poached. But then eventually you have to understand that these are all these are not contracts. I mean, a player is fully competent to contract, so therefore you can't say that a player can be influenced by some third party or a club. Eventually, the privity of contract is between the player and the club. I mean, the first club. There is no privity of contract between the first club and the second club. So therefore, it would be a very uphill task for say club A to get any kind of relief except for injunctive relief. Of course, if they are able to satisfy the court that damages is not it is not compensable in damages, then of course if they will seek specific performance, they will have to back it with an injunctive relief that they will seek. So therefore these are two faces of the coin. One relief is that Mr. X or Miss X be compelled to keep playing for club Y during the subsistence of this off season. And the second prayer will be injunction restraining club individual Y from playing for any other entity, including club Z. So therefore, obviously, where such an injunctive relief is sought, it will have its consequences even for the other club. And maybe the other club will be made a party to the suit so that they know that there is a dispute, and they know this will also be a deterrent for them in certain situations to kind of engage with this player, because they will know that tomorrow if we put in money and we engage him, he may suffer a court injunction and then he will not be able to play for us. So obviously they will know that, you know, it might be putting money in the wrong basket. So that is, I mean, that this all depends on the facts of a given case and how, you know, the parties decide to proceed in the matter. So there cannot be one general answer to that question.
So, Shatadru, in your experience, I'd like to know, I'm interested in knowing, like, in sports, it's clear for us to see that in sports organizations or sports competitions, there are a lot of complexities. So there can be litigations arising from a lot of intricate matters, right? In your experience, can you, without getting into specific details, maybe, can you explain to us or give us an idea or give us an anecdote of a certain interesting litigation in a sports organization that you've come across in your experience in your time?
Yes, of course. So I would do that. So, you know, you see, it is not really, I have come across more than one instance of a similar situation, because lot of the litigation in India concerning sports bodies is in the context of sports federations. So sports federations are typically bodies through which sports federations or societies are, where it operates at three levels. It's like a pyramid. Say, for example, if you take any Olympic sports, at the top of the pyramid is the International Olympic Association. At the first tier under that, you have the Indian Olympic Association, and then the Indian Olympic Association will then have its there'll be a state association which is affiliated. There's a state Olympic Association also, and then there will be sports associations which are affiliated to the state Olympic Association. And of course, there will be a National Sports Association also, which would be affiliated to the Indian Olympic Association. So this is how it usually, the structure works. So, so in this structure, there are several possibilities of a dispute. So at the very first, at the bottom of the pyramid is the association, which is basically the body which is responsible for any given sport. So whether it is cricket or hockey or football or tennis, so there will be a particular state level association which will be responsible for the conduct of the affairs of that sport in a particular state. Now that association will obviously have its members. Who will be its members? Its members will be the different clubs or the different entities which are conducting, which are participating in the state level or district level competitions. So these entities will be typically organized in the form of societies having a registration with the society with the registrar of societies in that particular state. And they will be organized. So a society, like a corporate entity, has its own, is a jural entity. It has its own recognition in law. It can sue and it be sued in its own name. And it is the affairs of just as the affairs of a company are conducted by board of directors, the affairs of a society are conducted by its executive committee or subcommittees. So there could be, so therefore these are all elected, these are democratic bodies. So the members of a committee are elected through a process of election. So there, and it will have a set of office bearers. There will be a president, there will be a secretary, there will be a secretary general, there will be a treasurer, there will be executive committee members. So therefore the first level of dispute will be would arise in situations where there are different contesting parties which are trying to get elected to the to the executive committee of a particular society or a particular club. So this is the first level of dispute. The next level of dispute becomes as to say that, say if you have a state level tennis association or state level cricket association, it will have different constituents. So different clubs, etc., will be members of the state level association. So now there could be a dispute at that stage also. So for example, the different clubs and constituents will elect the office bearers of the state association. So there could again be a dispute over there. There could also be a dispute where in certain sports, for example, it is not structured in a manner that there is there are different state level associations, and the state level associations go and participate in the national association. It could very well be that there are more than one entities, or there are more than one, there is no tier, so to say, of a state association like that. So they could be directly, you could have a national level association, and the different constituent members are members of the national level association. Possibly it is in football, it is something, to my knowledge, as far as I know, there is a lot in sports such as hockey and also in football, it is something like that. So for example, you will have the National Sports Federation of a particular sports, and its members will be different clubs and associations which are conducting the sports in their respective states. So therefore, of course, it will all depend. So now you'll have to then look at the bylaws of the National Sports Federation. So whether that provides that you will have 2 representatives from a state, or it provides that there'll be 1 representative from a state. How will you determine which is that association which is going to be the representative of a particular state? There will be a set of objective criteria to decide the affiliation of that or the representation of that sports of that club or their association at the national level. So this is the second level of dispute. There could also be a dispute as to election of members to the national federation. Then the next level of dispute is when you go to the international federation. So the international federation typically will have one. So if you have, you see one, you so therefore if, for example, if you look at the International Hockey Federation, so the International Hockey Federation will typically have 1 representative from India. Now that particular so for example, if there was a point of time where the 2 different associations were fighting it out before the International Hockey Federation. So they were trying to, then the questions would arise as to what are the objective criteria that the international association prescribes. So it could include objective criteria such as, for example, affiliation with the National Sports Federation, or recognition by the International Olympic Association. So therefore, at the international level also there could be a dispute. And now you have the Court of Arbitration for Sports in Switzerland, in Lausanne in Switzerland. So which is a body which has been constituted internationally to look into this kind of dispute. So I remember we had in fact represented one of the national sports bodies before the CAS, which was a few years back. So therefore it has there are different levels of disputes that can arise. And of course there are also disputes in the matter of grants, in the matter of recognition by the Ministry of Sports, in the matter of derecognition, where a particular sports, for example, there is a National Sports Code. So one of the grounds on which a sports body may say be de-affiliated or maybe de-recognized is if it does not satisfy the requirements under the National Sports Code, or one particular body may be given preference over another because it satisfies the requirements under the National Sports Code. It has that kind of a constitution which is compliant with the requirements of the National Sports Code. So therefore, these are all, there are complex issues which arise as a result of the manner in which sports bodies are so to say structured. And it is like any other, there is power play, there is there is a lot of competition so as to decide who is going to control the affairs, from the just as in elections, from the municipal or the district level right up to the parliament, you have different levels of competition. So similarly, in the world of sports also, right from the district level right to the national and international level, there is a lot of competition and a lot of it is a tough battle so as to represent the district, the state, the nation in different sporting bodies.
Right. Yeah, this was pretty interesting. I'd like to bring the conversation back a little bit to what Shatadru touched upon right at the beginning, where he talks about how vast sports law is as a field per se. And we have so many other sections when it comes to sponsorship and broadcasting rights disputes and so on. So in general terms, for an individual, if they wanted to be competent enough to deal with issues like this, would you be getting an understanding or an education if you do sports law in all these sectors, or are these subsections under sports law where you can do just player contracts or just things pertaining to sponsorship or just pertaining to broadcasting rights issues? Do you need to be need to have some specialized knowledge in these particular areas per se to tackle these problems, or if you just do sports law and you will be able to understand all these different branches that you spoke of?
I don't think that we have that level of specialization, at least in India, that you can look at only sports contracts. Or I mean, we are still moving in that direction, but it's still very early days, and you cannot really, I mean, of course you can get a specialization from a university in India or abroad. I don't know if there are Indian universities offering a specialization, but possibly they are diplomas. Now, if you get an international, you attend an international university where they are teaching sports law as a specialization, you may possibly look at these different dimensions. But to say that, and in jurisdictions where there is that degree of specialization, there is a lot of work in a particular field. For example, there is a lot of work in a subset, as you mentioned, like for example in player sponsorships or employment contracts of players, or in the field of broadcasting of sports. So then there could be lawyers or professionals who are specializing in those areas. And I mean, Ainesh will also agree that it could apply similarly for people who are sports managers and who are in the area of funding or in the area of managing sports entities and players. So unless there is that level of specialization, you cannot really, it is not reasonable to expect that people can limit themselves in that sense.
Okay, all right. And to Ainesh in particular, it's quite interesting because I understand that you are in transition from a management source to law per se. So for you personally, how did you go about, or what got you interested to make this transition? And at this point, what do you see in terms of transferability of skills, where your management background is helpful in trying to help you settle into the law sector of it?
So, sports law in general has really always sparked an interest in me because of, like, in management also contracts play a big role. Management is all about contracts basically. So when I was basically like, watching these football deals and all these, they're really interesting. And both my parents being lawyers, I've always seen them work firsthand. So law was always something I wanted to know more about. But in school, we were never really told what law was really about. We just had commerce, science, and all that. So, but when I actually met Shatadru. I spoke to him. He told me a lot. He taught me a lot about different aspects of law, and that really sparked an interest in me. And I noticed a lot of similarities between what I had studied and what was happening in law. It was just about finding a solution. The law was, yeah.
So, I have a question. Like in general, if I were to pursue a career in sports law, right? What would your advice be? Because what I gather from what Shatadru said is to practice generalization rather than specialization, because it might not exist in India, right? So, if I were to venture into a career in sports law, is there an opportunity to specialize in it? If not, even if I pursue a general law degree or general career in law, are there enough opportunities for me or enough projects available to me to invest in, sports law as a domain?
Yeah, so the
Uh,
point, Ainesh, I think you should take this
Sorry,
one.
before he takes over, like I just because I was looking at sports law as a thing, I just want to say a couple of things. Like basically, when I was looking at sports law, it's not that big in India as of now, but that is also because sports has just taken a major step in India, like because of the IPL, because of the badminton premier, like all the sports have been getting a league on their own. The sponsorships, the money, everything is flowing in very recently in India. So that's why I feel like sports law will definitely grow into something big, but right now it's still in its beginning stages. So there's not much specialization there, but yeah. So now I think he can explain it to you better.
I agree with what Ainesh has mentioned, that eventually the viability of a professional career in any field is dependent on the kind of economics involved and the extent to which there has been commercialization, or there has been, as I said, it's the role of lawyers or document or people preparing documents, or even any other, I mean, fund managers comes in depending on the volume of transaction involved. So as Ainesh rightly mentioned, that sports commercialization of sports is only just picking up in India, and until even 10 years back, it was only cricket. And you see, because tennis was always there, but tennis India it is not really it is an individual sports. So when it comes to individual sports, the degree of commercialization is not comparable. I mean, it could be even assuming that you had, Indian teams have played, I mean, comparatively quite decently in tennis, or for example, if you look at a sports like billiards or even badminton for that matter. But because these are individual sports, uh, the degree of commercialization is all the more lesser, because it eventually boils down to individuals, and it is obviously a certain degree of elitism is attached to individual sports. So say you cannot expect a tennis to become or even golf to become as popular a sport uh, uh, amongst the large number of people as say a cricket or a football can. And the reason, and that directly impacts the commercial exploitation of that sport, because obviously sponsors are going to put in their money in a particular sport which has a wide viewership, and viewership would again depend on how accustomed or how familiar rather people are to that particular sports. So for example, a cricket is something which is understood in every nook and cranny of this country. Likewise, for a very long time, hockey was one such sport. Football in certain parts of the country is understood in widely. But say a tennis or a golf or a billiards would not be understood in the same way. So therefore, you cannot be corporate sponsors are not going to put in their money in something which would not result in that kind of commercial exploitation. Beyond, say, of course, for example, you might have a few big sports stars in these fields. Like, for example, you had Leander Pace. So there could be sponsors who are interested in investing in Leander Pace as a brand. But not so much in tennis itself, because that sport would not garner that kind of commercial value as say a cricket would, which would be watched by people on television, which would be watched by people in stadiums, which would be listened to on the radio. So therefore, eventually, uh, as and when there is greater commercialization, there is greater interest in sports, and it reaches the masses of people. Uh, there will be more sponsorship, there will be more investment. And as there is more investment, as there are, you see, if you just look at the volume of player contracts, I mean, the kind of money that is involved, it is minuscule compared to say base, basketball players in the US or baseball players in the US. Compared their contracts with say footballers in India, I mean, it's not even comparable. So therefore, cricketers are there, but you even then, I mean, it's not comparable to what top sports persons earn internationally. So obviously, so if you see a movie like Jerry Maguire, which was about sports law in a sense, so there basically it is because of the kind of money, kind of volumes of contract that those players were entering into, that you had a lawyer, a very dynamic character of the protagonist who was chasing these sports persons, who was chasing their sponsors, and who was making a living out of it. So obviously that kind of hectic activity would not be there in India in the arena of sports contracts, because you, first of all, you would not have that kind of competition. And secondly, you would not have that kind, I mean, of course, IPL has been a game changer. So IPL is probably a comparable situation where you actually have clubs vying and fighting to get these players, and the players are in a position to kind of up their values and to up the bargain. But other than IPL, for example, in football, I don't think there is that kind of situation today, that you have players who can really bargain with football clubs and say that if you do not pay me X, I'll go to Y. It hasn't picked up to the same level. As and when it does, obviously the stakes will go up, and as the stakes go up, professionals like lawyers, like professional managers, uh, like people who are in the field of media and broadcasting, all these people will, even event managers, all these kind of people will get, their volumes will also go up depending on the overall volume. So because eventually these are all, law is also service industry. So a service industry typically depends on what the real business, or the cream of the real heart of the matter is in the business or the activity itself. And service industry is always ancillary to that. So law would always be an ancillary field. So it would be ancillary to the main commercial activity, which in this case would be sports. So if the volume of sponsorship goes up, people like lawyers would have more business. So, but they themselves are not a productive arm of the economy. Lawyers are not a productive arm. They are always you should see, for example, in a company, you have people who are employed as lawyers, but they're always the overhead, because lawyers and accountants are basically servicing the company itself. They are not earning money for the company. So therefore, even when they're working as independent individuals or as organized as firms of lawyers, they are not really earning money. They are servicing the needs of an industry, which requires their advice or requires their assistance, so as to go ahead with these contractual relations. But they are not really bringing in money in that sense. So eventually, so the job of getting a sponsor will probably be that of a third party, of a professional whose job it is to get a sponsor. Although in sometimes there is a lot of, it is not as clear cut as that, and there might be situations where professionals are straddling different roles. I mean, they are also getting you a sponsor at the same time they're helping, but it's not, strictly speaking, theoretically, that is not usual. I mean, eventually you will have to engage a professional manager. For example, a sports person will need a professional manager to get him to get him employment with the club. The profession, it's not the lawyer's job technically to get that. At least in India, it is not like that. In the US, for example, it might be different. But in India, typically lawyers will come into the picture only after the basic commercial understanding is in place and the player has already been approached by the club, and then the lawyer comes into the picture to draft out the documents or negotiate on behalf of the player or the club, as the case may be.
So, we do completely agree where it is nice to see now that there is a lot more sponsorship being poured in, for example, to Pro Kabaddi, to the ISL, things like that. Sports are getting a lot bigger in this country and there is more investment. So hopefully we will reach a stage where, players are adequately compensated and you can have hyper specializations in the field of sports law. There was one situation just before we wrap up. There was one situation that I wanted to kind of talk to you guys about because it's very interesting from the perspective of sports law. It was the FIFA, like, it's a FIFA situation. It was a FIFA World Cup that was held in Brazil. And I'm not sure if you guys would be familiar with it, but what had happened essentially was FIFA at when it is when a country wins the bid to kind of host the World Cup in their country, when all the kind of stadiums are being built, the infrastructure is being built. FIFA comes in and kind of has their own, like they set up their own courts of law in the country that are specialized to deal with all the FIFA disputes and things like that. And one major dispute that had happened in Brazil was that in every stadium in Brazil, it was a law that you could not consume alcohol in the stadium because they had had incidents where it had kind of got a bit violent, which is why there was a national law that said that alcohol consumption in stadiums was illegal. Now FIFA came and they kind of set up their courts, and they passed a law that would kind of overrule this law because one of FIFA's biggest sponsors is Budweiser, and so they passed a law that would say that Budweiser could sell their product at the stadiums. Now, I wanted to hear kind of your perspectives on how they can kind of strong arm this country's government into kind of caving and allowing them to sell alcohol when it is nationally illegal for them to do that.
I mean, that's a product of the capitalist system. So anywhere, I mean, multinational corporations have that kind of power and influence over to kind of influence governmental policies. So that is true for why only a multinational corporation, even say a Tata or maybe a big Reliance in India has that kind of leverage with the government or with the authorities or the powers that be to kind of influence national policy. So, I mean, that is nothing. I mean, I'm sure if special treatment, honestly, I'm not very well acquainted with the facts that you mentioned, but assuming on what, just assuming whatever you stated, if, for example, Budweiser was being given preferential treatment, it would be open to some other liquor brand to maybe challenge it in a court and say that this is discriminatory treatment. You can't, and that arrangement with Budweiser would then have to pass the scrutiny of the court or authority, or whatever these FIFA courts, as you mentioned, that which are faced with a dispute like that. So there are always situations like this, but you also have the courts and the tribunals and other authorities which are meant to resolve these issues. So, for example, if a leading judgment in the field of sports law in India is that of Zee Telefilms, where the contract of Zee Telefilms was cancelled by BCCI, and Zee Telefilms approached the courts and eventually the Supreme Court, where they filed a writ petition against the BCCI, and the Supreme Court eventually held that the writ petition, I don't know how familiar you are with it, but writ petitions are basically filed to invoke the extraordinary jurisdiction of the High Courts and the Supreme Court. Typically, these are under the Constitution. This is an exercise of constitutional remedies, which are available to a party which is aggrieved by actions of the state. So it typically does not apply to private respondents. So where the respondent is a state, a party can approach a constitutional court such as the High Court or the Supreme Court to seek relief. Now, Zee Telefilms was trying to contend. So there are certain tests which the courts have laid down in India to determine what is a state body. So one, of course, is ownership. So if, for example, the government of India owns over a certain percentage of the shareholdings in a corporation, that becomes a part of state. It also depends on whether it is a statutory body. For example, the Airports Authority of India, it's a statutory body. So it is formed by statute. So therefore, it automatically becomes part of an instrumentality of the state. Another test, which in the facts of BCCI, the majority view of the Supreme Court was that BCCI is not state. So writ petition under Article 32 would not be maintainable. But the Supreme Court also said that there might be situations where a private body performs public functions. So for example, so the jurisdiction of the Supreme Court under Article 32 is more limited than that of the High Courts under Article 226, which is also a similar power to be exercised against state bodies. But the Supreme Court said in Z Telefilms that it would be open in a given situation for a person aggrieved by the actions of a private body performing a public function to approach the court and to say that no, this although it's a private body, because it is performing a public function, it is akin to state. So therefore we don't have to file a civil suit or go to a long drawn process. We should be given justice under the constitutional framework. So therefore it is because in a situation like this, where today, if say the FIFA was to do something in India, possibly a petitioner could file a writ petition in the High Court and say that FIFA is performing a public function because FIFA is promoting a sport of football, which is in the nature of a public function, because it is sending a team to represent the country internationally. So that is in the nature of a public function. Of course, I mean, this is left to a particular case. We are not today arguing a case against FIFA, but I'm just suggesting that there are different recourses that are available. So if FIFA were to do something like what you're mentioning happened in Brazil, possibly Kingfisher could approach the court and say that no, how can Budweiser be given this kind of treatment? And then, of course, the court would be called upon to decide that, first of all, to see whether the action itself falls within the constitutional scheme, or, of course, it could relegate the parties to some other proceeding, such as a civil suit. And they would say that, no, this is not a public function. So therefore, we will not get into it in exercise of our powers under the Constitution, but you can file a suit, or you can file a civil proceeding or an arbitration proceeding, depending on the contractual arrangement that you have. So there is always a recourse available. All actions which are taken by private or public individuals in a country, at least in our system, is open to judicial review. So there is always a recourse available for parties, for corporations or entities to challenge actions of the state or of independent institutions or sports bodies. And as and when these things, parties approach, knock the doors of the courts are faced with these situations, and the courts deal with those situations on a case-to-case basis. As on date, there is no codified sports law in India, unlike some jurisdictions, but it is in bits and parts. So there is a sports code, then there is a law which governs associations, then there would be judgments of the Supreme Court and High Court which would govern various aspects of sports law in India, but there is no one single codified statute, so to say.
Also, like, coming to your question, like how could FIFA overrule it? If you see, like we spoke about it earlier, it was about bargaining power as well, right? Because FIFA holds the bargaining power here. Because if they pull out of Brazil with that tournament, FIFA World Cup is one of the most watched sport. Like, it is the most watched sport. So if they pull out, it will be a huge loss to Brazil in their different sectors.
I think the issue there is they also don't provide adequate financial kind of support to the host country, but I understand like how they would hold all the chips in that situation.
All right, guys, with that, we've come to the end of the episode. Thanks a lot, Shatadru and Ainesh. Shatadru, good luck to you, and Ainesh, good luck for your applications. Rick and Arjun, thanks for being amazing hosts. We'll see you guys next time.
Yeah, thanks to all of you and for giving us this opportunity to reach out to and try to be of some kind of hopefully some kind of assistance to your larger pool of people, followers, and we look forward to further association in the future.
For sure, for people listening with who don't have an understanding of this domain, it's been really useful for us as well, because for us this was an introduction into sports law, and it covered various aspects of it. So thanks.